persons who have done the same thing. One is dealt with in a way that vindicates their Section 35 rights, and they get a trial, a proper trial as we all know it. The other one does not get that trial. It's the same as the distinction that is made with respect artificially about the case of P.W. Botha. Of course, P.W. Botha was charged under the Commissions Act. Of course, we all know that. But what is it? Let's forget about these artificial things. What did P.W. Botha do? He defied a commission of inquiry. What did President Zuma do? He defied a commission of inquiry, assuming he's guilty of that. The point of the matter, the difference between P.W. Botha, the way he was treated, and the way this court treated President Zuma, is that P.W. Botha ended up going to court, getting a suspended sentence or a fine and so on, having all his rights of appeal, and he actually exercised them and appealed. Whereas former President Zuma did not have that. He does not have even the right, which this court said is so sacrosanct in terms of Section 35(3)(0). This court said in the case of Zukudza, State versus Zukudza. I don't know if the court received we sent some authorities yesterday, but let me cite it anyway. 2000-11 BCLR 1252 CC.
We did receive it, Mr. Mpofu. I received it this morning.
Thank you. Okay, then yes, that's paragraphs 11 and 12 of that of this court's judgment of Ackerman J are crucial. Towards the end of paragraph 11, the Leonard Justice said, an important aim of the right to a fair criminal trial is to ensure adequately that innocent people are not wrongly convicted because of adverse effects which a wrong conviction has on the liberty and dignity and possibly other interests of the accused. Let's just pause there. What does in the Section 35 is not just there to ensure, and this is the point that kills the distinction between a conviction and a sentence. Section 35 is there to not just to protect you against the wrong conviction, but about anything wrong with the process of that trial. There are, however, other elements of the right to a fair trial, such as, for example, the presumption of innocence, the right to free legal representation, a trial public, which is not unreasonably delayed, which cannot be explained exclusively on the basis of averting the wrong conviction. It's not all about a conviction, but which arise primarily from considerations of dignity and equality. Now, dignity and equality has no eyes as to whether now we're dealing with sentence, now we're dealing with Section 174, now we're dealing with this or that or the other.
Mr. Mpofu, may I please
of course.
take you to the matter of Mr. P.W. Botha. Would a more apt comparator not be this? If after Mr. P.W. Botha had disobeyed the commission, there had been an application to court for him to be ordered to comply with a summons. This is on the assumption that the Conciliation Commission also issued summons, to comply with a summons issued by that commission. And then upon his failure to comply with that summons and therefore not here before the commission, in accordance with that summons, for there to be an application for contempt of court, wouldn't that be a more apt comparator? Because there was no question of the interposition of any contempt of court. So on that basis, at least at face value, it seems to me that there is no comparison at all.
Okay. Justice Madlanga, I have to say this again, I'm sorry. Of course, that would be the best comparator in the world if B.W. Botha was also an 80-year-old person from Kandla and so on. That's not where I am. I am saying B.W. Botha committed the crime that just former President Zuma is accused of. I'm at that level. The people out there don't know these niceties about whether this one did this or did that. But what they know is that there are two persons who robbed a bank. And the one bank robber gets a suspended sentence. The other bank robber gets 15 months in jail. Now, of course, it
is exactly why I want you and I as lawyers to disabuse those people of false impressions that they might have, because you and I at least do know some law. I will not say we know all the law, but you and I at least know some law. So we should disabuse their minds of any wrong impressions they might have. And no, for the reasons I gave, your comparator is not an comparator, but of course, yes, you are still responding.
Yes, Justice Madlanga, please, if you hear nothing else I'm going to say today, just hear this. It does not matter what crime we're discussing at a particular time, whether it's stealing a loaf of bread or killing 1 million people. I am saying both those accused, the one who stole a loaf of bread and the one who killed 1 million people, are equally entitled to Section 35 rights. That's what we're here about. So I'm not going to stand here and say, no, B.W. Botha, yeah, this, and then, no, he absconded, and then, that might well be. I'm not interested in that. I'm interested only in saying crime in South Africa imposes upon a court, any court, including this one, duties, certain duties. Those duties are listed in Section 35 of the Constitution.